Alex here with a legal nuts and bolts video on the adverse inference rule. So first off, not all 50, maybe all 50 states have it, but I don't think they do. Nevada only had it, from as far as I know, maybe a couple of decades ago, maybe less than that. The rule basically covers the destruction of evidence. Now, I'm not talking about the willful destruction of evidence. That's actually something that goes back probably a lot longer than just a couple of decades. And if you can show, I don't even know if it requires clear and convincing evidence, but I think it does. If you can show that somebody willfully destroyed evidence that would have hurt their case, you can get a pretty good sanction out of that, up to and including a default judgment, which is pretty insane. You just win your case outright without even having to go and prove anything. Well, I mean, you proved that they destroyed evidence on purpose. That's something that goes way back. That's not the adverse inference rule. The adverse inference rule covers the destruction of evidence that wasn't willful, but that the person who destroyed it had a duty to preserve. And I'm just going to go ahead and use the example of, I believe, if I find the case, I'll post it in the description below. But the last time I read it, and my mind is kind of fuzzy on it, but if I remember correctly, it was a water park in Nevada. If I remember correctly, somebody slipped and fell and hurt themselves, and a surveillance camera caught the incident, and the water park destroyed it because they had a process in place where the surveillance video was only retained for a certain amount of time. And their defense in the courtroom was, well, we didn't destroy it because we were worried it would ruin our case. We just destroyed it because that's what we always did. We had this, I don't know, let's just say for this video, we had a rule that after 90 days, we destroy a video unless corporate says we need to keep it. A few of the defenses that they made were they didn't know they were going to get sued, and they didn't know a court case had started, things like that. And basically when the Supreme Court of Nevada discussed it, what they said was that, well, first off, you don't have to be sued for the duty to preserve evidence to trigger. You just have to have a reasonable idea that you might get sued. That's good enough. I'm not even sure if that requires a threat from anyone. I think, like somebody slips and falls, cracks their head on your floor, and they have to go to the hospital. That right there is probably good enough for you to know you better not destroy that video because you might get sued. And they should have, put in some kind of I don't know, exception system where under certain circumstances the video, or maybe they already had those circumstances. You should have probably widened the parameters on that to preserve videos that might need to be used in court, just in case you get sued. Anyway, what happened was they created the adverse inference rule, and it wasn't as strict as what I said before with the, if you happen to prove that somebody destroyed something on purpose because they didn't want to lose their court case, which is just an outright victory. I mean, it's in the case law, it's in the rules. You can just win by default if you can show that. It's not quite that severe. It's not quite that impactful, but it's easier to assert in court because you don't really have to show that they did it on purpose. All you have to do is show that they had the evidence and that they should have known they were going to need it. You don't have to go into why they destroyed it. You don't have to try and crawl into their mind and prove that they were evil. You can just prove that they were incompetent. It's a lot easier to do that. Once you do prove that, the adverse inference rule will trigger. Adverse inference rule will trigger. And basically what it says is you're allowed to tell the jury, instruct the jury that that if they want to, they don't have to, but if they want to, they can assume that whatever evidence was in that video that was destroyed or whatever other thing that happened to get destroyed, they can assume that whatever was in there would have been harmful to the person who had the obligation to preserve it. That's it. From what I've seen, because I've seen a few other cases go up there where it was used, it seems to be a really powerful rule. It seems to me like it's getting used. It seems like jurors are assuming that they destroyed it, so it must have showed something bad. Like I said, from what I've read, the jury doesn't have to assume that there was something adverse in the video. They have the option to, but it seems to me that once the jury is instructed on that, big giant corporation didn't save a video, it doesn't look good. I just wanted my viewers to know that that rule existed. I thought at the time that I read it that it was a really great idea because otherwise it's just too easy for somebody to have video set up all over the place to use to protect themselves in a lawsuit or to sue other people, and then when it turns out that it's not going to be beneficial to them, to destroy and come up with some cockamamie BS excuse as to why they did it. Just it's too easy to do that. So I like this rule. I think it's really cool. And if anyone here has any questions or comments on it, or if it surprises anyone, I bet it surprises some people that Nevada has something like that. Go ahead and post it in the comments below. I'm also curious if anyone is from a state that has the same rule in their state. I'm curious. I don't know if it's in all 50 states, but it would be nice to know if it's something that's in most states, or if it's something that's kind of spreading out there. To me, it sounds like common sense. I don't really have anything else to say on it. So with that, I'm going to go ahead and end this video.